Did you meet Heather?
Yes.
Okay, good. Okay. All right, this is about as good as I can.
Okay, I don't think we've got.
That's on.
Okay, we're on. Okay, it looks like people are still wandering back from lunch, but maybe if we get started, they will come a little more quickly. So I'm going to moderate this afternoon panel. Actually, we're going to be going all afternoon, including after the break, with 4 presenters and hopefully some time for questions and comments from the audience. I should introduce myself. I'm Mark Scolacci. I am a professor of law here at the law school at Colorado. I teach in the water law area, very interested in all the issues. I thought it was a terrific set of presentations this morning, and we have what I think will be an equally fascinating set of presentations this afternoon. I'm not going to go through any detailed introductions here. You have those in your brochure, but let me just briefly introduce our speakers. I'll do it as they come up. We're going to try to keep people as close to on time as we can, but we have a little bit more time built into this schedule for this afternoon's presentation, so hopefully we'll be fine, and we'll just kind of see how it goes. I've warned the speakers that if they go too long, I'm not going to let them take questions, so it's all on them if they don't make time available for questions. All right, so let's get started with Burke Griggs, who is a professor of law at Washburn University in Topeka, Kansas. Burke's working on a whole bunch of really interesting stuff in Kansas. He and I have talked about a number of issues that they're facing there in Kansas, and he's worked on lots of issues involving interstate compacts and the like. And Burke's going to talk with us today about 50 years of litigation over interstate compacts, particularly how they affect groundwater. So welcome, Burke.
Thank you, Mark. Doug also gave me an impossible task. No problem, right? It's Woody Allen. He takes a speed reading class. What's it about? War and Peace? It concerns Russia, okay? If my presentation concerns anything coherent, it's going to concern groundwater. The groundwater has been a major driver over the last 5 decades of interstate litigation. All of you, or at least the lawyers in the room, are probably familiar with the basic ways in which states allocate rivers. The court can do so through its powers of equitable allocation. That goes all the way back to Kansas v. Colorado, the first one in 1907. The court doesn't like to do this, though. When it has equitably allocated these rivers, it has done so by issuing a decree, but these decrees are fairly rare. We have one on the Laramie River, we have one on the Delaware, we have one on the Vermejo, but we don't really have many more of them. What we do have are a lot of interstate compacts. After the Supreme Court ruled that the prior appropriation doctrine would be applied across state lines in Wyoming v. Colorado, this focused the Western states' minds on establishing interstate compacts because that would stop the race to develop water. The final and outlier is congressional apportionment. Congress first did this on the Rio Grande at the turn of the 20th century, did so most famously, and some would argue incorrectly, in Arizona v. California in 1963, which led to the equitable apportionment of the Lower Colorado and the Gila. But I'd like to give you a slightly less conventional history. States have taken very extreme legal positions in these cases. The granddaddy of them all, as Keith Jackson would say, Kansas v. Colorado, 1902 to 1907, Colorado made a series of very aggressive legal arguments. First of all, we're a prior appropriation state. It's in our Constitution. We've appropriated the whole river. It's all ours. And secondly, we're going to use this argument that McKinley's Secretary of State used in the 1890s. The natural resources originating within the boundaries of any sovereign country are the property of that sovereign country. So, why are we even here? It's our water. It's all been appropriated. Kansas had the opposite approach. They had a different water law system. They were common law riparian, reasonable use. Therefore, Colorado could not really impede any flows into western Kansas. The United States, through the great Morris Bien, at the same time was claiming all of the unappropriated waters of the West on public land. So we had these very aggressive and extreme legal positions. they also had very extreme hydrological positions. Colorado had one of my favorite arguments, and in this case definitely rewards rereading. They said, court, you don't even need to apportion this river because we have two rivers. One originates, up by Twin Lakes and Leadville and comes down through Canyon City and Pueblo, and then peters out right around Hawley, which is pretty convenient if you've ever been in Hawley, okay? And right around there, another river emerges, a plains-type river, and that's the one that flows into Kansas and down into Oklahoma. So we've got two rivers here. And if you've driven the river, that passes the laugh test, okay? Kansas argues it's one continuous river. The Supreme Court again says no, this is one continuous river. And why do we know this? Contemporary USGS reports, first decade of the 20th century, very solid understandings of the hydrological connection between surface and groundwater. And the court has remarkably good and prescient language about how human-induced groundwater pumping would deplete stream flow. So, about the first 5 decades of the 20th century, you have the Great Reclamation Act, you get the beginning of interstate litigation. The court establishes its power to equitably allocate a river. I mentioned Wyoming v. Colorado. In 1938, the Hinderleiter case establishes that interstate compacts govern intrastate allocations of water, even if you have pre-compact water rights. So a 1945 compact trumps an 1895 water right. Okay, a very important case. And that, together with the New Deal, spurs probably the most productive decade of interstate compacts. You have 6 major interstate compacts between 39 and 49. You have the Pick-Sloan Act, and then finally the first major case setting forth the modern rules of equitable apportionment. So everything's great. We have Supreme Court decisions setting the rules. The government has responded. It's going to build reservoirs. The states are in that great line that you hear in every first article of every interstate compact, interstate comity. What could possibly go wrong? And here's Neville Chamberlain. He's holding a copy of the Rio Grande Compact. It's a great year in American history. Well, this is what happens. Okay? This is John Browning, proud son of Utah, and his water-cooled machine gun. It rendered trench warfare obsolete overnight. Same thing happened here. Frank Zyback, a Nebraska tenant farmer living in Strasburg, Colorado, develops the center pivot irrigation system. The first example of Nebraska and Colorado colluding to screw Kansas out of water. Okay, these first pivots, there was so much hydrostatic pressure on these, they didn't need motors. And that didn't last for long. But what you have is technological disruption on a grand scale, and suddenly, well, not suddenly, it takes a couple decades, but you start to see depletions in stream flow, and you get these major cases. Now, I've listed 5 here because Montana v. Wyoming recently concluded. But I'll speak more about the Pecos and Arkansas River litigation and some of the Republican River litigation that I was involved in, and cover some of the themes I've touched on already. First of all, we see a return of extreme legal positions. Now, this is not strictly about interstate allocation in this slide. This is about, does the United States have a reserved water right to land that is adequate for the purposes of public lands? And the Supreme Court says in the United States v. New Mexico that for the primary purposes of the public lands, the national forests, then yes, the national forest gets enough water for the purposes of that forest. But they don't get water for secondary uses, aesthetic, wildlife, in-stream flows for trout and such things. And then you get a really sudden change in opinions out of D.C. about the scope of reserved water rights. You have a very aggressive opinion from Leo Krulitz saying that the USA, again, calling Morris Bien, has the right to the unappropriated waters necessary for the public lands. Now, there wasn't an embargo on any of the rivers that you saw in the 1890s and the 1900s, but that's a pretty aggressive position. Colorado's own Clyde Martz restricts the scope of that almost immediately, and then Ted Olson reverses it in 1982. And for any of you law students in the room, if you want to see, regardless of your politics, whether you like Ted Olson or not, one of the most impressive pieces of legal scholarship and writing I've ever come across professionally is this Olson opinion. It really lays out things quite nicely. So the United States is swerving quite wildly during the same period that states are beginning to think about pulling the trigger on interstate litigation. So we see a return of extreme legal positions in the Republican River litigation. The Republican River Compact, it's a river, first of all, that most Coloradoans don't even know exists. You can't really kayak on it. You can't water ski on it. You can usually walk across it and not get your feet wet. But the compact allocates the so-called virgin water supply of the basin. Kansas argues that groundwater is part of the virgin water supply. And this helps Kansas because under Kansas water law, groundwater and surface water are part of the same legal regime. Why did Kansas do that? Because they got tired of suing Colorado and not getting a decree from the court. Why did the court not give them a decree granting them relief? Because Kansas couldn't quantify its water rights. How do you quantify water rights? Imperfectly, but through the prior appropriation doctrine. Okay? How have you been harmed, Kansas? How much water are you short? And then as FDR starts to build reservoirs, as reclamation comes into these interstate basins, how much water do you need, Kansas? Well, we don't know. So in 1945, Kansas adopts the prior appropriation doctrine statewide. And so they're committed to this, and they're arguing, obviously, that the Republican River Compact governs groundwater from within like 3 inches of the molten core of the earth all the way to the surface. Okay? It's all part of the compact. Nebraska? No, it doesn't. We don't see the word groundwater in the compact. Get out of here. Motion to dismiss. Compact does not cover groundwater. Why? Because Nebraska law governs surface water under the prior appropriation doctrine, but delegates groundwater to regulation by local natural resources districts under common law, riparian, reasonable use doctrines. Colorado splits the baby. Why? Because of its 65 and 69 groundwater acts. Colorado's position is alluvial groundwater, part of the compact, Ogallala groundwater, not part of the compact. I'm detaining you on this to show how happily these legal positions in front of the Supreme Court accord with the respective water laws of the party states. But in one of the smarter opinions, I think, in interstate litigation is Special Master McCusick. He doesn't play this hydrological taxonomic game. I don't care what you call it. I don't care what your laws are. To the extent to which pumping affects surface flows, that groundwater is part of the compact. And with that finding, Nebraska's goose is basically cooked. So the states get into settlement talks quite quickly. But we haven't seen the end of these legal arguments. Okay, a more recent case, Montana v. North Dakota, it's almost like I changed the names of the states and it's the same slide, right? Montana, the Yellowstone River Compact, governs groundwater. Wyoming, no it doesn't. We don't see the word groundwater there. But we're willing to renegotiate the compact because we're that nice, right? Special Master Buzz Thompson, no mean fool when it comes to water law. Doesn't have much patience with this. He goes to the intent of the parties. He goes into contemporary Wyoming and Montana state laws and denies that. But we also get extreme technical positions, not just extreme legal positions. In terms of groundwater modeling, Texas v. New Mexico, the first interstate groundwater-driven case on the Pecos River, the states came up with competing models. There's a great book about this case by M. Hall at University of New Mexico called High and Dry. And basically the states were more focused on how their respective model would get them as much water than they were about accurately modeling the river. And Special Master Myers saw this a mile away. He threatened to develop his own groundwater model, and that sobered up the states, and they developed a shared modeling approach. But if you want to talk about the Battle of Stalingrad as applied to interstate litigation, it has to be Kansas v. Colorado. There were 270 trial days, figuring 12 to 15 days of prep for each trial day. 200 days of those concerned modeling. Kansas's lead expert, Timothy Durbin, had a nervous breakdown on the stand. Kansas had to rebuild its case. This is not gossip. This is in the special master's report about why Kansas had to refile and retry its case. Kansas eventually prevails on the modeling issue in terms of the model itself, but there's also an extensive fight over what are the appropriate model inputs for evapotranspiration, the Blaney-Criddle method versus other methods, and so on and so forth. So you've got these extreme positions, and so this is where you have the states fighting over models. Well, it would be better if states didn't fight over models. This seems to be the consensus, right? So that's what happened, like I said, in the Republican River case, after McCusick's finding that groundwater pumping that affected stream flows was part of the compact. That gave the modelers a fairly clear description of what the model should accomplish. So the USGS plus the other 3 states built a modflow model in fairly quick time, and it's been criticized as being imperfect and flawed and unsophisticated. And I don't have a lot of patience with those arguments, frankly, because I think that's the technical make the perfect the enemy of the good. You have a special master decision saying, model, do this. And the model does that, and the states have agreed to the method. And the states have fine-tuned the model over the last couple of years, the last couple of decades, really. More recently, I think this is an interesting point to make. Montana is suing Wyoming for groundwater-induced depletions to the Tongue River Basin. The Tongue River Basin is a tributary of the Yellowstone. Part of this is related to dewatering of coal bed methane wells. They don't have a model for the Tongue. They probably can't afford a model. Models are very expensive. They're very time-consuming. So what do they decide to do? They decide to borrow the closest model nearby. It's a BLM model for the Powder River, and do their best to transpose that model into the Tongue. Could it have built a Tongue River model? Perhaps, but these are expensive. But what do you need for that model? You need Wyoming data. What state are you suing? Wyoming. They're not eager to hand over any data lest you weaponize it and use it against them. Okay? So here you have a pre-existing groundwater model that eventually does not succeed. Special Master Thompson says there are too many problems with this model. Montana's argument about depletions does not meet the burden of proof that Montana needs to do. And I'll come back to this. Remedies, we have equitable remedies. They're quite rare. We asked for an injunction in Nebraska because we saw the graphs that you saw this morning. We saw a growing separation between base flow and the surface flows of the river, and we wanted a retirement of about 300,000 irrigated acres. The court is not going to go and tell a state how to change its water law. We didn't expect to get an injunction, and we didn't. But the court has ordered hard limits on groundwater pumping. That was one of the key victories Kansas secured in Kansas v. Colorado. One of the key victories Colorado secured, and this is not written out enough, I think, Colorado secured much more control over federal reservoirs in the basin than Kansas wanted. And I'm not going to talk about that because that's not groundwater. In my case, the Kansas v. Nebraska case in 2015, we had a final settlement stipulation. The parties had settled to an agreed Republican River model, to agreed accounting procedures, And then Nebraska used as its major part of its counterclaim that one of the major reasons it was not in compliance was that the accounting procedures were actually a mistake. And we could not prevail here, and it's still my biggest disappointment. If you're a lawyer, in order to open up a contract under mistake, what do you have to prove? That the mistake was mutual. This was not a mutual mistake. This was a deal. And if it's a mutual mistake and you've proven that it's a mutual mistake, what's the remedy? You rescind the contract. You start all over. And this settlement stipulation is like the Holy Roman Empire, right? It's neither holy nor Roman nor an empire. This thing's neither final nor a settlement nor a stipulation anymore, right? Because, the court signed off on this in 2013, and Nebraska convinced the court by a 5-4 decision to open up a settlement agreement and change some of the terms. And I'm detaining you guys here because as we go into the settlement phases with interstate cases, I think we have less confidence in what the next settlement would be in terms of will the court reopen this. Rarely do we get river masters. We have had them on those rivers. Texas v. New Mexico on the Pecos, that established you can have money damages, not just water. This decision comes out in 1985 or 1987, sometime there. The day after this decision, Kansas starts to refile they start rewriting their petition in front of the court because they've sued Colorado asking for money damages. It can include prejudgment interests. And in our case, Kansas got the disgorgement award, which is highly unusual, that in a typical contract case, if you've been wronged by someone else's breach, you get what you would have gotten had the contract been honored. But in this case, the court gave us the unusual remedy of giving us money that drew from the profits Nebraska made from breaching the compact. I think one of the most important reasons why we got that was we had this earlier case with a shared groundwater model, with shared accounting procedures. Nebraska knew exactly what it was doing and just didn't respond to water shortages quickly enough. However, the damages awards make a lot of headlines. But what I want to emphasize with this slide is the cost of complying with the compact decision out of the court are usually an order of magnitude higher. In Texas v. New Mexico on the Pecos, the parties agreed to a stipulated damages amount of $14 million. New Mexico has paid over $100 million in land retirements and augmentation plans and other things to comply with the compact. Similar situation with Kansas v. Colorado on the ARC. That's the first time the court has awarded damages in an interstate case, but Colorado has spent more on retirements and reductions in pumping. The biggest number I could find, and I probably couldn't defend this on cross-examination, but on Kansas v. Nebraska and Colorado on the Republican, on a yearly basis, this was a big award, okay? This is just 2 years, $5.5 million. These other cases were for decades of noncompliance. In Kansas v. Colorado, it went back to 68. In Texas v. New Mexico, it went back to the 50s. But the state of Nebraska especially has invested a lot of money in augmentation plans, pumping groundwater and putting it into the stream to zero your balance in the compact accounting. And even though it spent over $100 million on these plans, their argument is that without augmentation, we would have had to retire about 300,000 acres of irrigated land. Gee, where'd they get that number? That's the number we were asking for in our petition, and a decline in assessed land values of about $500 to $900 million. So the states are doing the cost-benefit analysis and finding that it's worthy of this. Well, how do you comply with the groundwater portion of an interstate compact? You can treat the cause of the disease. If the disease is groundwater depletion, the cause of the disease is excessive pumping. So you can reduce that. You can reduce irrigated acreage. You can chase federal subsidies. Or you can address the symptom. What's the symptom of groundwater depletion? Dry stream flows. Treat the symptom. Pump water into the stream. Problem solved. Okay. I think the jury is out on whether augmentation methods of compliance at the interstate level are a suitable long-term compliance method. But I think there is an issue of how durable these will be. Interstate litigation has also changed state water law profoundly. I mentioned the Kansas situation. In the Ark River Basin, the state engineer, Jairus Danielson, this is a fun story. He's on cross-exam. No, he's not on cross. Kansas brings him as a hostile witness and gets Danielson, who's a pretty colorful guy if you've met him, to admit that under Colorado's 1972 pumping rules, pumping actually had increased after the issuance of those rules. So after our decision in that case, the Ark River rules tightened up considerably. Nebraska, however, has a problem that Colorado doesn't have. It has a different system for groundwater than it does for surface water. But in a very darkly Machiavellian approach to interstate compliance, and I'm not objective about Nebraska, I can't claim to be. I was paid to sue Nebraska. I was like the happiest state employee in Kansas for 6 years. I would have done this for free, right? But they paid me. This is the problem with the legal system that does not integrate groundwater and surface water. The state has the authority to regulate prior appropriation surface rights. The state does not have the authority to regulate groundwater. So when things go short, what happens? January 1st of every year, Nebraska Department of Natural Resources issues closing notices on every water right in the Republican River Basin from the Colorado line to the Kansas line, and then lifts those on a case-by-case basis. Meanwhile, groundwater pumping continues largely apace. This has generated at least so far 7 inverse condemnation cases in Nebraska, and so far the surface irrigators have not prevailed. But it's a case of first in time, last in right. You have an 1894 surface water right, and you're in Willa Cather country. You're in Red Cloud, Nebraska. Your family's been irrigating off this river since, the 1890s, and you have to watch the water flow by during times of drought. So, what does all this mean? You can boil it down to some simple things. Groundwater is part of a compact water supply. That's just not a winning argument. It can slow things down. It gets you a motion to dismiss, right? That that the special master is going to have to hear. But it hasn't slowed anyone down yet. It hasn't prevailed yet. I'm sorry. It's definitely slowed things down. But groundwater can also be used as a surrogate for stream flows through augmentation plans in the Pecos, in Colorado's portion of the Republican, and in Nebraska's. The position of the federal government, however, is not consistent. There are often good reasons for that. There are often not good reasons, and I'll try not to dwell on that. Now, we have 3 cases before the court. Professor Hall is doing me a big favor by taking, in many ways, the most enjoyable case, Mississippi v. Tennessee, but I'll summarize it quickly. The other 2, one's a compact case on the Rio Grande. The other is on the ACF Basin. There was a temporary compact, but the states, which so profoundly detest each other now, you're never going to get a compact in this basin. So I'll try and conclude with a summary of these and maybe some concluding remarks. Many of you are probably familiar with the Rio Grande suit. The Rio Grande Compact is unusual. It has an explicit reference to a reclamation project, the Rio Grande Project Act, which built Elephant Butte Reservoir. So the compact, which is federal law, and the federal law of reclamation are explicitly present in this compact. And irrigation districts on either side of the line agree to a water distribution plan. The reclamation blesses it, but the New Mexico state engineer opposes it. Why? Because he has jurisdiction over water in New Mexico, not the Bureau. This effectively forces Texas to sue. So in 2014, they sue. Their argument is New Mexico's violated the compact. They've also violated the Rio Grande Project Act by taking groundwater seeping from beneath Elephant Butte Reservoir and allowing that seep water to be appropriated by New Mexico irrigators. Okay? New Mexico's response, because it's their turn to make some extreme legal positions, right? Why should we be left out? Kansas has done it, Colorado's done it, Wyoming's done it. Well, New Mexico law, not the compact, governs the distribution of this water. Okay, that's an aggressive position. Everyone moves to intervene. The New Mexico State Pecan Growers Association moves to intervene. Why? People aren't trusting their state engineer. Who's going to defend our surface flows? If the New Mexico State engineer is allowing groundwater rights to be appropriated downstream of Elephant Butte, we are at risk as surface irrigators. So it's pretty crazy there. Special master denies New Mexico's motion to dismiss, says the equitable apportionment prohibits, the doctrine of equitable apportionment prohibits New Mexico from doing what it's doing beneath the reservoir. New Mexico can't capture this water. Once New Mexico delivers water to Elephant Butte, it has surrendered control over it. And if you're the state engineer for New Mexico, you can see how that's not an argument you like. The court grants the United States' motion to intervene last year. This is still, I'm sorry, the special master report, but denies other motions to intervene. And I'm going to linger here. The United States, very aggressive in this case, wanting to be a party. The court, in two decisions this year, approves the special master's recommendation, allows the United States to intervene, and I think this is the first time a non-party has been allowed to intervene to enforce the compact. It's a pretty remarkable development, and it makes sense. If you are Justice Gorsuch, it makes a special sense dealing with the importance of the Rio Grande Project Act, Elephant Butte Reservoir, but also our treaty with Mexico on this river. There are good reasons for the United States to be involved. However, about a month later, special master is discharged with the thanks of the court. And we have a new special master in that case, and I was telling one of the lawyers for Texas this morning, I gave her my condolences because trial was going to be in New Orleans. Now it's going to be in Cedar Rapids, Iowa. Probably in February, I don't know. So this brings us to the next case, Florida v. Georgia. This is the Apalachicola, Chattahoochee, Flint River Basin. That's the Apalachicola. That's the Chattahoochee. That's the Flint. It begins above Atlanta in the northeastern part of the state. And Florida's argument is basically that excessive groundwater pumping around here and management by the Corps of Engineers on the Chattahoochee has starved Apalachicola Bay, one of the most important oyster fisheries in the country, of water with devastating economic and environmental consequences. Georgia's response, well, it's your own fault, and it's also the Corps' fault. Since the Corps manages this part of the basin, there's not a lot the state of Georgia can do. The Corps stays away from this litigation. The United States does not enter it. Special master makes a point in his report of saying the Corps was conspicuously absent during the trial. Not one member of the Corps attended trial, even in the gallery. Like, how did he know? You know? So, the upstream state, this is interstate litigation, right? Of course the upstream state's guilty, okay? Georgia has screwed Florida out of water. It has even granted groundwater permits during drought emergencies. That's a tasty tidbit from that litigation. I guess it was too much bureaucratic friction to not grant them, so they just kept granting them. But Special Master Lancaster makes this point. The Corps manages this basin. If the Corps manages the basin, the Corps is not a party to this lawsuit. So I don't know if I can order any relief that will actually be effective. So after a 200-page Special Master report, 17 days of trial, a very experienced, very learned special master says, I recommend dismissal. And oral argument, Justice Breyer says, what do you want us to do here? Well, you're the Supreme Court. You can do quite a lot. I'm going to flag this for Professor Hall. Mississippi Fred McDowell, he lived in Tennessee and Mississippi, so I think he's a good symbol for this system. People want to claim him. If you're in Tennessee, he's from the Mississippi Delta, which extends into Memphis. If you're in Mississippi, he's from Como, Mississippi, and that's the end of it. But this is a cool case because there's no river involved. This is about the Mississippi Embayment Regional Aquifer System, or MERAS, and there is a layer to this. If you're in Mississippi, it's the Sparta Sands Aquifer. If you're in Tennessee, it's the Memphis Sands Aquifer. So the USGS very diplomatically combined that. This provides really high-quality drinking water to the city of Memphis. So the argument is that this pumping is harming Mississippi. So it's a regional aquifer system, and you can see that highest, most brown circle, that's the city of Memphis. And that's the impairment and the depletion they're complaining about. Here we go. It's never too late to get into the game. What's Mississippi's arguments? Trespass onto the sovereign property of the state of Mississippi. The Magnolia State will not accept this offense. Okay? Conversion, trespass, and that's real money. $35 million. I mean, you can't do much with 35, but 615, you know, you're into Russian yacht territory at that point. Tennessee says, what part of 120 years of federal common law and interstate water don't you understand? This is an interstate resource that needs to be equitably allocated. Dismiss. The United States agrees with Tennessee. Extreme technical positions. This is one of my favorite things of all time, but I'm a water geek. Mississippi argues, well, you know, if you look at this, that's an interstate aquifer. Because an aquifer, you know, that's the geological formation that contains the water. But the water, that's not an interstate resource. Why are you laughing? So the long-dead Colorado lawyers who argue the two rivers theory in Kansas v. Colorado, right? One from Twin Lakes all the way down to Holly, the other one from Holly into Oklahoma. They'd be pretty proud of this, okay? Special master says the doctrine probably applies. The doctrine of equitable apportionment probably applies. But because this is an original jurisdiction Supreme Court case, where you need to build your own record at the level of the Supreme Court, you don't, you know, the record doesn't close once the trial's over, there will be hearings on this. And I wouldn't be surprised if some people in this room have worked on models pre-existing this litigation that should be very important here. The USGS has a pretty good grip on what this aquifer is. They've been studying it for a long time. So, wrapping up, I got about 3 or 4 more slides. You've been very patient. Extreme legal positions, extreme technical positions have been a hallmark of this litigation, even into the modern era. The importance of historical analysis. What did the parties intend when they made a compact? That's been quite important. However, in the Rio Grande case, Special Master Grimsall did his own historical research. It's a very long opinion. And one of the gossip things out there is maybe this is what got him discharged with the thanks of the court. Colorado was concerned, and New Mexico was concerned. And in their exceptions brief to the Special Master's report, they said, you can do this, Judge Grimsall, but we don't want this to be the law of the case. We don't want your own individual historical analysis to govern the law of the case. That's an interesting thing about historical analysis. These are some warning signs I see. The first one is what I call the idiot savant defense. And this is what Wyoming did. First, you make some arguments that there are probably some Wyomingites in the room, and I'll buy you a beer afterwards. I apologize. But first, what do you say? Groundwater is not part of the compact. Secondly, we'll renegotiate the compact. Thirdly, There's no Wyoming state law on the connection between groundwater and surface water. Seriously, the state of Wyoming, right? Oh, we don't have any data on that, actually. So, you've made arguments about how you're wrong, how you're ignorant, innocently, but you're ignorant, and you don't see the word groundwater in the compact. Montana does its best with a borrowed model. And there's Steve Larson, one of the best groundwater modelers out there, lead expert for Montana, doing his best to defend this transposed Tongue River model into the Powder River into the Tongue. And here comes Willem Schroeder. So Steve Larson's got a cricket bat at a baseball game, right? And Willem Schroeder's throwing his usual 95-mile-an-hour fastballs. The model doesn't hold up. Okay, this is a problem. This is something where the USGS can help with modeling. Secondly, I've talked about augmentation as a troubling compliance method. I could go into the anti-federal sentiment here. This is something I see in my basin. An interstate compact is a double-sided bargain. States make deals with other states, and the states make a deal with the federal government. And we're seeing the second part of that bargain ignored by states that don't like federal jurisdiction over surface water in interstate basins, and I think that's a very concerning thing. Over the long term, courts operate in legal time, not hydrological time. And in my case, we saw Nebraska surface irrigators join the Kansas case because they knew that they would be just as harmed by excessive groundwater pumping in Nebraska as our surface irrigators would. So it was the hydrological boundary between groundwater and surface water, which I know doesn't exist. I got Professor Konikow right there looking at me, okay? But jurisdictionally, that boundary does exist in Nebraska. So water boundaries are meaning more than state boundaries. So what's the federal role? Very quickly, in our case, you have an interstate basin with upstream reservoirs supplying downstate irrigation districts. Reclamation was not involved. In the Rio Grande, same basic facts, reclamation has been deeply involved. What is the federal position? What about the Corps in the ACF? I think this was a very big issue. And Special Master Thompson and I are working on an article right now that so far most people have hated, but most people we've talked to are lawyers for the United States. Should the United States surrender its sovereign immunity if the Supreme Court accepts an interstate case? Something worth talking about. Well, who cares about these boring rivers, right? This is not the Colorado. This is not, the Cache la Poudre, these beautiful rivers where there are non-catfish living in there and you can do other things. Okay? Well, that's why Colorado River Basin was dewatered by 41 million acre-feet in 10 years. And that is not water supply that reclamation can control. It has the keys to Meade and Powell, but it will never, ever, mark my words, have control over groundwater supplies in the Colorado River Basin. So this is a big deal. So I'll close. I stole everything from myself. This is an article that this is based on. And my good friend J.D. McFarland has the last word. Attorney General of Kansas, they're meeting somewhere in Lamar, Colorado. We have our armies massed at the border. And if you know J.D., he was waiting weeks to say this. What are they going to drink? The structural superiority of the upstream state. In closing, I would like to give a kudo to a very good friend of mine who died very recently, David Hill. He is the brother of my father-in-law and a real gentleman. I never won a political argument with him, but thank you very much.
Thanks, Burke. I have lots of questions, but we're going to have to hold them until the end, I think, here. So let's jump right in with our second speaker, who is Noah Hall. Noah is a professor of law at Wayne State University. I first got to know Noah before he got into the academy. Noah and I used to fight over the Great Lakes Compact in the early 2000s. Noah won the fight. Well, he won the fight in the sense that the Great Lakes Compact was passed, but I'm still not persuaded that this was a good thing for the Great Lakes, and we continue to fight over it. Anyway, Noah, in his typical fashion, is going to go against the script here, so he is scheduled to be talking about the Great Basin in Utah and Colorado, but he tells me not a whole lot's going on there. I guess he can clarify that, and he's going to jump in where Burke just left off to talk a little bit more about the water dispute, the groundwater dispute that's going on between Tennessee and Mississippi. So welcome, Noah.
Great. Thanks, Mark. That was nice of you. All right. Great. Thank you. Thanks, Doug, for inviting me. But I got to thank Mark in particular. He's right. I've known Mark and worked with him for, I don't know, it's probably getting closer to 20 years than I want to admit right now. I came to know Mark when I was an attorney working with the Council of Great Lakes Governors, essentially negotiating and drafting and really designing the Great Lakes Compact, which is a very different model. And I got to say, Mark was exactly the type of academic that a legal practitioner hopes to run into. You know, ready to engage, discuss, patient, and you learn what you think you're arguing with him, and you might think you're even making good points, but really you're learning when you're talking with him. And I actually almost recall, this is a lawyer's mind, I can recall standing here right now verbatim of some of the discussions from 15 years ago. He's been just a really good friend and mentor since. And thanks for everybody for bringing an Easterner out here to Colorado. I love this university. I've wanted to be a student here several times in my life, and personal commitments kept me from that, usually one relationship or another. And I worked here for a summer, what you guys do here and what you're continuing to do with environmental law here is really spectacular. And those of us in other places appreciate it. That said, what I was invited to speak with you guys about today, I'm not going to do, but for a good reason. And if I needed a better reason, it's that Professor Griggs basically said everything I would have said anyway. And here's an odd one. I agree with everything the previous speaker just said. Everything. I would plagiarize that entire talk if I could. I have very little to add except maybe just a few wrinkles. But let me now get everything back into order. I was invited to speak about the ongoing dispute between Utah and Nevada over the Snake Valley Aquifer, a relatively small water supply in that border area. Dispute has been brewing between those two states for, I don't know, I guess it's been about 10 years now. It's a pretty straightforward dispute. Essentially, Las Vegas apparently needs water. It's a city, and doesn't get a lot from the Colorado River, thanks to you guys. And so they've been, Nevada, through the Southern Nevada Water Authority, or whatever it's called now, has been looking to rural Nevada to augment the water supply for many years. The area of rural Nevada that the Southern Nevada Water Authority was looking to do more groundwater extraction is transboundary in nature and would have affected Utah. And so what would have been an intrastate water dispute, and a fairly typical intrastate water dispute, essentially between rural communities and a distant city, had the potential to turn into an interstate water dispute. And here's where I was wrong. I thought, actually, Bob Adler, another just really great friend and mentor and helper in this work, helped bring me out to Utah, I don't know, maybe 5 or 6 years ago on the Snake Valley issue. And back then, I think I said pretty publicly and loudly that I thought this was going to be the first groundwater dispute before the Supreme Court. I was like, it's heading there. It's a dry place. People love fighting about water. There's plenty of water lawyers there. You guys know how to do interstate litigation. This is the case that's finally going to make it to the Supreme Court square on the issue of groundwater. Not with groundwater connected to surface water or groundwater implicitly part of a surface water management system, but just about the groundwater itself. And I said, luckily, though, you could avoid the interstate litigation, the Supreme Court fight, by entering into a compact. And of course, Nevada and Utah's bureaucrats, and I use that term right now, complimentary, Utah and Nevada's bureaucrats drafted an excellent interstate groundwater agreement that I remarked at the time I thought had a lot of the elements that we want to see in cooperative interstate groundwater management, most notably protection of surface systems and the ecosystem that's dependent on groundwater. Well, for various reasons, that fight never happened. Sometimes fights just don't happen. I'm not entirely sure why Utah has always been reluctant to sign what seems to be a pretty good agreement that they were involved in drafting. I suspect it's just politics over conceding to Nevada and Las Vegas water in a very water-stressed part of the country. I don't think there's really good substantive reasons why either party has a problem with the agreement. And the dispute mostly has now shifted to intrastate forums in Nevada, contested cases before the state engineer over the water withdrawal permits. So there's nothing left to talk about there, or at least not much, except as a footnote, if ever you need to come up with a really good interstate groundwater agreement, you might want to Google around for this one that Utah and Nevada drafted up 5 years ago that was never implemented into law, but is a really good piece of work. I would plagiarize it. Instead, the first groundwater dispute to reach the Supreme Court came out of what's thought of as the water-rich East. The Mississippi-Tennessee case over Memphis's groundwater use. And nobody would have predicted that this would be the first U.S. Supreme Court case for several reasons, including that the U.S. Supreme Court denied cert 5 years ago, which usually puts you on pretty solid ground to say, I don't think this is going to be a Supreme Court case. I don't have to watch this one anymore. The backstory, as Professor Griggs said, is, again, I think fairly straightforward to water dispute folks. Memphis is the second largest city in the United States that relies exclusively on groundwater for its municipal supply, San Antonio being the largest. Memphis has grown. That part of the country is essentially has had population and economic growth over 30 years, and with resulting increases in groundwater pumping. And taking the facts, I was about to say taking the facts in the light most favorable to Mississippi, but that's going to be very hard to do. Let's at least take a step there and take some of Mississippi's allegations as true, that essentially Memphis has been pumping more and more groundwater from an aquifer that underlies part of Mississippi, and you'll see why I'm having a hard time phrasing this in a moment. Mississippi claims that Memphis's groundwater pumping has depleted the groundwater property of Mississippi, exactly as Professor Griggs said, valued at $615 million. To be very clear, this is a simple tort claim of conversion. The same as if Professor Griggs took my water bottle, more or less. And I'm saying that was mine, its market value, it's a little dinged up, is $12, you owe me $12. It's that simple. And of course, nothing in water is that simple. I will note, you had this on your bullet points, which was great. Mississippi, by the way, has hired outside plaintiff lawyers working on contingency for this case, which really does raise an interesting question of whether it's about the water or about the money. And for many of you who've done interstate water fights, my hunch is they were not really about money. They were about water, which is one of the few things worth more than money. But Mississippi says, nope, the water's not really worth anything to us. It's an economic good, it's a piece of property, and the legal system can fairly compensate us for its unlawful taking, in their view, by simply writing a check. And as property law folks know, that's not what property is. Property is more than the money even, but not in Mississippi's view. All right, so why were we all so wrong about this case? Mississippi brought suit against Memphis 10 years ago now, 2007, claiming that the groundwater was the sovereign property of the state of Mississippi. It's entitled to the $650 million for damages for conversion. District court tossed it, said you're ridiculous. It's an interstate resource subject to equitable apportionment. Bring an equitable apportionment claim before the Supreme Court. There was a lot of, to me, very interesting federal procedure relating to water law, whether, for example, Tennessee is an indispensable party to a suit, given that it's the state, not the city, that ultimately has the sovereign responsibility over its water resources. But we could cut through all that. To make a very long decade litigation story as short as I can, Mississippi's claim that it owns the groundwater within its territorial boundaries as property was rejected by the district court, by the Fifth Circuit, and in a cert petition by the U.S. Supreme Court. That brings us up to 2010, 2011, something like that. And then somehow, some way, some lawyer wrote some cert petition 4 years later that convinced 4 justices of the Supreme Court, I guess this would have been 2015, to grant cert to Mississippi, reviving this, not only this failed litigation, but as I'll discuss in a moment, essentially a failed legal argument, and bringing it back to life, and potentially, and why I think it's of interest to this room, as crazy and outlandish as an argument as it is, and we'll basically be discussing the same things, we all need to be prepared for the possibility that this is a live Supreme Court case. And 4 justices granted cert. After all of the turmoil of Supreme Court appointments, apparently there was like an election and nominations and whatnot. We even sought to get review improvidently granted. Maybe one of the people who voted cert is no longer on the court due to natural or other forces. But the Supreme Court stuck with it. They doubled down. And then here was the really interesting part, at least to me. The Supreme Court, about 2 years ago, appointed a special master. Now, this is odd, because if the Supreme Court granted cert on Mississippi's tort claim of conversion for unlawfully converting its property, there'd be no need for a special master. This isn't interstate equitable apportionment litigation. There's a straightforward legal question here, whether this is the property of Mississippi, and if so, it would get remanded down to a district court for a conversion claim. But instead, the Supreme Court appointed a special master. I can't explain any of this, and I'm not going to try to make up some explanation when I'm not a member of the court with any firsthand knowledge. But the result is a lot of reason for both confusion and potential uncertainty as to the legal status of groundwater, especially with respect to interstate claims, but potentially for intrastate use as well. So Eugene Seiler was appointed special master. For interstate water law geeks, you might have noticed kind of a recent disturbing trend. The Supreme Court used to hire water law profs to do this gig. I see a few in the room I'd love to see as a special master. But now they're starting to appoint retired judges, senior status judges. And Seiler comes off the Sixth Circuit, so the special master proceedings are being held in Nashville. He's been doing, I think, a very good job. There's a really well-maintained docket page. Briefings have been going really well, but it's going to get more convoluted. So Judge Seiler gets handed this case as a special master. And he doesn't know what to do with it any more than any of us do. Is this an equitable apportionment dispute over a shared water, or is there some new law here that says that water is the property of a state, like a state office building or a state car? And Judge Seiler says, well, first things first, we got to figure out this question, even though this is supposedly the question that's assumed to warrant the cert in the first place. The parties do another round of dispositive briefing. Professor Griggs covered all this. And you said it perfectly. It was essentially what should have been a motion for summary judgment. As a matter of law, the case law is entirely uniform, and the facts are almost unavoidably in Tennessee's favor, that the Sparta-Memphis Aquifer or the Sparta-Sands Aquifer or the Mississippi MESA, whatever that thing stands for, aquifer, it's an interstate resource. The same as a river, the same as the Great Lakes, the same as wild salmon off the Pacific coast. It's an interstate resource subject to equitable apportionment, and that should be that. Tennessee, which at this point, when I say Tennessee, is really three parties. It's Memphis Power and Light, the utility, the city of Memphis, and the state of Tennessee. They've all now teamed up and have a unified counsel team. They have their own lawyers, but a unified counsel team. Wrote persuasively, maybe for the 8th time or something, that this is subject to equitable apportionment. It's an interstate resource. And the simplest fact, if you take no other fact in Tennessee's favor, is the allegation by Mississippi that Tennessee, without crossing into Mississippi's territory, staying on Tennessee's side of the border, is engaging in an activity, pumping of groundwater, that is having an effect in Mississippi. That is, by definition, an interstate resource. It seemed like a fairly unavoidable legal conclusion. And Judge Seiler seemed to agree, and then said this very weird thing, which you noted, said, if this was a motion for summary judgment, and I was sitting as a district judge, I'd toss this on summary judgment. Then he said, but this isn't a motion for summary judgment in district court. It's a initial determination by a special master in the context of an interstate water dispute. And so for some reason, he applied something very different than the Federal Rule of Civil Procedure standard. Something almost like, is there any chance whatsoever that this argument is not completely out of nowhere? And under that standard said, let's do 2 years of briefing and evidentiary hearings. And that's where we are right now. So the little win, by the way, for Tennessee is Tennessee convinced Judge Seiler to allow another round of dispositive motions. And that was just filed. In full disclosure, I have not been given any access to confidential information by Tennessee. In part, I'm currently serving as Special Assistant Attorney General for Michigan for the Flint water stuff, so I don't want to be in any way representing the sovereign state of Tennessee. But keeping everything objective and arm's length, I've certainly had plenty of discussions and shared public work with Tennessee's legal team. Tennessee just submitted its 12th motion for summary judgment last Friday on the 1st, and Mississippi now has, I believe, July 6th, their reply brief will be due. And Tennessee's argument is, of course, the same argument they've made over and over again. There's a body of law that covers shared interstate resources. It's called equitable apportionment. Use it or go away. And Mississippi has continued to stubbornly dig in their heels that on first the foundational legal point that water within the territorial boundaries of Mississippi is Mississippi's sovereign property. And I don't know if you used the term Harmon Doctrine. You did. You had it. Yeah. This is for international law folks. This brings back the Harmon Doctrine from 1892, which I don't even like calling it the Harmon Doctrine because as far as I can tell, it never became doctrine. Nobody ever really bought this thing. The idea that you could do whatever you want within your territory. If the Rio Grande starts in your country, take it. Do whatever you want. It's a political boundary is the same as a property boundary, and that's the end of it. This has never been the law. I mean, Harmon wanted it as the law, and I don't even think his own administration bought into it. He didn't make it the law in terms of international relations at the time. The Supreme Court has rejected it in every setting of interstate disputes. And it also, even going to just the core of water and property, it makes no sense. This is not how we treat water even at the state level. Why it is that 4 Supreme Court justices are very interested in this argument still? Good question. And certainly their interest means that we should be interested. Mississippi's other argument, that aside from the foundational legal argument that this is just state property, is they've now flipped positions and said that the aquifer is wholly intrastate. Or at least, we don't know, this is a little speculation because their brief will be coming in July 6th, and they're not going to share it with me before then, is that they've now started to differentiate the Sparta sands, the Memphis sands, and the Mississippi embayment, there you go, the big one. For starters, Mississippi is claiming that this aquifer is not connected to those other aquifers, or if it's connected, it's distinct. I have sat in a room with hydrologists arguing over even an intellectual conception of a distinct aquifer that the water flows between. And even as a lawyer, I can't get my head around that. And not to mention Judge Seiler's order says, the question is whether the aquifer is interstate. And I don't want to pick on a judge for not being a hydrologist, but of course the aquifer is just the geologic formation. It's the water in the aquifer. All this to say that, yeah, for scientists who say that lawyers struggle with groundwater law, with groundwater science, I guess you guys are right. We don't do a great job with it. But that's because the law struggles with a resource that we call fugitive, which is a really negative term for what God makes and flows around, but because it doesn't fit our conception of property and boundaries, we call it fugitive. And so lawyers are always going to struggle with this, and law is always going to struggle with this until law just gets its head around the idea that boundaries are just not that big a deal and we shouldn't worry about them that much, but you guys aren't going to do that. So Mississippi is also now claiming as a technical matter that this is not an interstate resource. Assuming that Judge Seiler again rejects dispositive motions, there is going to be an evidentiary hearing in January of 2019 about whether this water body, whether this aquifer is inter or intrastate. The easy thing to do is just to dismiss all this. Intellectually, this is a terrible argument by Mississippi. I was criticized from my colleagues for even writing about it. They said, this is such a bad argument, where are you even, but with the Supreme Court hearing it, we have to give it some credibility. The concerns I have with it, let's talk about concerns. I'm going to wrap up and get to the other speakers because I think you guys want questions. The concerns with it, I think, should play out far beyond interstate. What Mississippi is looking to do is bring back the state ownership doctrine. And going back, you really have to go about 150 years back into Supreme Court, U.S. Supreme Court legal history to find the state ownership doctrine with any legs. The state ownership doctrine suggests that water, wildlife, and other natural resources located within the state are the state's sovereign property. And the state's relationship to those resources is that of an owner, a property owner. Now, to be very clear, the Supreme Court has since rejected this. In fact, the Supreme Court described the state ownership doctrine as a mere 19th century legal fiction, and I'll add this part now, which any water law student should be able to write 3,000 words on final exam time as to why it is either inaccurate or incomplete in describing a state's relationship to its water resources. I would say a state's relationship to its water resources is that of a trustee. It has police powers. It has parens patriae. It can undertake litigation against other states. That is not the same as being an owner as state property. But if groundwater is held in the context of Mississippi versus Tennessee to be sovereign property of the state, everything we've talked about today, and I've been thinking about it as all these talks have been going on, is in flux. Everything from private rights to groundwater would have to be revisited if the groundwater is the state property. Regulation of groundwater use should be revisited. Any takings arguments involving groundwater would be revisited. And really the entire balance essentially between private and public interests in water would shift with this state property notion. I obviously don't think it's a very good idea, but it's one that we have to be on guard for. I've offered, I'll wrap up with this, I've offered a little bit of an alternative. I don't know if it's a better one. I don't know if it's, and my hunch is it's probably not gonna find many followers. But I've suggested that there might be a better doctrinal way to deal with this. I'm actually not a fan of equitable apportionment. And actually now I get a chance to go back to the arguments that I had with Mark Scalacci 20 years ago. I do not think the best way to manage any resource is to try to quantify it and allocate out rights to it based on a quantity. It's a way, and it's a way that we learn, and it's a way you guys do out west a lot, and it works. It's easy to administer, and it's got predictability, at least until conditions change, and it's got some other good things going for it, but it's not really how we do it in the East. We don't apportion waters in the East. We don't measure the flow of a river and decide what, who gets what amount. And we certainly haven't done that with major water bodies like the Great Lakes. Instead, we've taken an approach in the East, unlike equitable apportionment, that's really better described as nuisance, which is that let's say it's a stream or a lake or even the shared aquifer. One person's use is going to impact another's. We don't need to decide who has what share of it. We don't need to allocate quantities. And in fairness to Mark, his proposals were far more nuanced and would solve a lot of these problems. But fundamentally, any scheme that divides and allocates is eventually going to deplete. Whereas a scheme that's based on a shared stewardship of the resource, limited through doctrines like nuisance, I think have a better shot at sustainability. So that if your use of the shared resource is unreasonably interfering with other uses, current, future, public, private, we look at that use and decide whether that use is proper in these circumstances at this time. To put it really bluntly, there's no reason to figure out how much water is in the Memphis Sands Aquifer, or even what is the Memphis Sands Aquifer, how much water is in it, how much Mississippi gets and how much Tennessee gets, let them use their share and fight over it. Instead, we could decide, is Tennessee's use unreasonable? Is what Tennessee doing causing harm that's not necessary or not warranted? Could their use be reduced? And take it as a matter of nuisance law. And in this way, I've suggested that perhaps moving forward, the Supreme Court might want to use interstate nuisance law rather than equitable apportionment in dealing with groundwater. And as one little piece of precedent, the Supreme Court, in effect, has done interstate nuisance on the Great Lakes. The Great Lakes have never been subject to an equitable apportionment. Competing uses by states are essentially litigated under an interstate nuisance standard, and it's worked pretty well. So that was my pitch. All right, that's it. Thanks.
Thanks, Noah. Noah's just sort of set out a polemic that might be worthy of some discussion after we get into questions and comments. I'll just throw out a quick response to what Noah had to say. I mean, one of the problems, and as Noah said, we've argued about this a lot. One of the problems with using a nuisance framework, at least to my mind, is that it's reactive, not proactive in managing water, and I don't think that's a good way to deal with water conflicts. The other thing I would say is that there is equitable apportionment, and then there is equitable apportionment, and you don't have to do it by simply allocating quantities of water to individuals. I've always advocated in these kinds of situations, and especially in the Great Lakes context, a sort of percentage kind of allocation that was based upon a cap, a kind of cap that would be determined by some higher authority that would presumably decide what constituted the health of the Great Lakes and what the lakes could afford in any given year. Anyway, it's kind of an interesting debate. Maybe we can talk about it some more when we get to the questions, but I don't want to go into the time too much there's somebody that just has to ask something over here. Were you?
Feasible to do a taking and just buy the whole lot up and then put something else back that's a greater value and send people the check for the increase in value it's created?
Well, there's a thought. I mean, let's get into that during the question period. I mean, it's an interesting idea, but I don't want to take away from Heather's time. So let me introduce our third speaker, and it's Heather Whiteman, runs Him. Heather is a member of the Crow Nation, and she's right here with us in Boulder, an attorney, a senior attorney with the Native American Rights Fund here in Boulder, and has been working on a lot of interesting issues. We're dealing with Native American water rights, and is going to talk to us today about the really interesting case going on over the Agua Caliente groundwater reserved rights. I think the Supreme Court just recently denied cert in that case. The Ninth Circuit decision is out, though, and I think I'm guessing that the tribes were breathing a sigh of relief that the Supreme Court didn't grant cert, but a lot of interesting issues really to deal with, and Heather's going to share some thoughts about that. Thanks.
Thank you, and just wanted to say thank you to the CU Law School for the invitation to speak and talk a little bit about our work at the Native American Rights Fund and focus on a case that we think is tremendously important and a very encouraging development in tribal rights and the ability of tribal nations to protect their natural resources and preserve their homelands. So I am a senior staff attorney at the Native American Rights Fund. For those of you who don't know about the Native American Rights Fund, we are a nonprofit law firm here in Boulder, Colorado. We've been in existence for 48 years now. We're looking forward to our 50th anniversary in a couple of years. And what NARF does is they focus on several priority areas: the preservation of tribal existence, defending tribal resources, and defending tribal civil rights and human rights. So those are some of the areas that we address in our work and that we really try to focus on. Water rights have become a very strong focus of NARF's work, partly because, as we all know and as we've all heard repeatedly over the past year and a half or two, water is life, and there's perhaps no place else where this is more readily demonstrated than on Indian reservations. So I'm going to talk a little bit about my client. I'm part of the team that is working to secure groundwater rights for the Agua Caliente band of Cahuilla Indians. This tribe is a desert tribe, and their reservation, we'll see a few maps a little later in the presentation that will really drive the point home, but they are surrounded by the Palm Springs resort complex that has sort of developed around their tribal land base over the better part of the 20th century. This is a historic photo that shows one of the first bathhouses that was built to develop the resort economy around Sekhi, which is a hot spring located on the tribe's lands in downtown Palm Springs, what is today downtown Palm Springs. Early on, the hot spring became very attractive to the Hollywood set that would like to come out to the desert during the winter months and enjoy sunshine and drier air, a nice climate in the wintertime when maybe LA is just not nice enough for whatever reason. Coming from eastern Montana, I don't really get it, but I like to go to LA in January. So that's sort of the background that this tribe has had, is this long development of a really robust resort economy on their tribal homeland and around their tribal homeland. And as I'm sure, how many of you have been to Palm Springs? Almost everybody. As you know, it's in the middle of the desert. It's really, really dry there. And there are these beautiful, dramatic mountains that rise up on three sides of the Coachella Valley and are probably the only source of groundwater that is readily discernible most of the year. So that's one of the sort of features of Agua Caliente is there is very limited surface water. It flows down through the mountains and basically sinks right into the desert floor before it gets down into the flatter lands of the valley. One of the most compelling things that we found early on in this case in our historical research was that the Cahuilla had always known groundwater. They had always developed groundwater. It was always part of what the Cahuilla people relied on to maintain their livelihood and to survive. This is a picture of a walk-in well historically in the Indian Wells, one of the suburbs kind of Palm Springs. Indian Wells was named after these wells that were dug by the Cahuilla people because they knew where the groundwater was. They developed the groundwater, they used it, and it was always part of their lifeway. So in 1876, the United States set out to establish reservations. They had initially negotiated treaties with various California Indian tribes in 1849 through 1851. Those treaties were squirreled away when they got to Washington, D.C. and were never ratified by Congress. This was not something that was, this wasn't information that was shared with the Indians for a number of years. They thought they had treaties, they thought they had secured a land base. They didn't know that the California congressional delegation, this very nascent state government, had gone back to DC and done some mischief and kept their treaties from being ratified and from becoming effective. So by the time we get to the 1870s, there's a need to set these lands aside definitively and provide some legal protection for the Indian tribes. The first executive order establishing the Agua Caliente Reservation was issued in 1876 by President Grant, and it was basically a very terse executive order, not really detailed, but it said we're setting this aside as a permanent homeland for these Indians. It was nearly immediately evident that the land set aside in 1876 was not sufficient to enable the tribe to have a permanent homeland. So in 1877, President Hayes issued an additional executive order setting aside more land. And that one was even shorter. It was just for Indian purposes. So what is an Indian purpose? Who knows, right? It depends on the tribe. Historical records do show that water was one of the major considerations driving the establishment of the reservation, the lands that were going to be set aside and the amount of land needed, as well as the location of the lands that were ultimately chosen to be the reservation. Several years prior to the executive orders establishing the Agua Caliente Reservation, Congress gave every other section in the valley for out to about, I think it was a 10-mile radius, to the railroads from the railroad line going out either side. And that was for the purpose of encouraging, the development of an economy, helping the railroads raise funds, and ultimately bringing settlers into the valley. The Mission Indian agents' statements during the era of the executive orders are extremely compelling, and they really demonstrate that water was a huge consideration in the establishment of the Agua Caliente Reservation in 1876 and 1877 in the years leading up to it. In 1873, Special Agent Ames wrote in one of his annual reports that the great difficulty arises from a lack of well-watered land. Water is absolutely indispensable for Indian settlement, and it would be worse than folly to locate the Indians on land destitute of water, and that in sufficient quality for purposes of irrigation. So it's really evident that the intent at that point in time was not just to leave the Indians high and dry and put some land there, but they wanted to put together a reservation that would enable them to take on the task of establishing a permanent homeland and an economy and providing for their needs and growing crops within the land base. So again, in 1877, Agent Colburn declared that his first purpose in determining the additional lands to be added to the Agua Caliente Reservation was to secure the Indians with permanent homes with land and water enough that each one who will go upon the reservation may have to cultivate a ground as large as he may desire. So here's a map that shows the current day, roughly the current day reservation. And you can see it's a checkerboard pattern with the sections that were allotted to the railroad previously on every other base of the grid. And we also see here is kind of a nice illustration of the location of the reservation interspersed with these very affluent resort communities that have grown up around the reservation. So that's a little bit of background about the reservation itself, and let's talk a little bit about, okay, well, these Indians are on a very nice location and they're surrounded by very affluent communities. Obviously, there's probably some pretty strong water infrastructure that has been developed around them over the years. Why go to court? Aren't your needs being met? Well, let's talk a little bit about the factors that drove the tribe to file a lawsuit against the two water agencies that provide water service within the Coachella Valley. The Desert Water Authority and the Coachella Valley Water District both serve areas within the tribe's reservation and provide water for a charge. They do charge the tribe for the water that is used on the tribe's reservation land base. But along with that concern, there's also the concerns about how the aquifer is being managed and what is happening to the aquifer as the water agencies struggle to offset the overdraft, the overpumping of groundwater to meet the needs of the communities that they serve. For decades, the tribe voiced its concerns about the degradation of the quality of water in the groundwater aquifer underlying its reservation. We looked very hard at the different reports issued by the water agencies over the years and looked at the patterns of water use and the patterns of replenishment and the source of water for the replenishment activity. So we're going to show you a couple of graphs here that really illustrate the very troubling situation that is developing within the aquifer below the tribe's land base. So circling back a little bit, in 1973, the water agencies began importing water from the Colorado River and using it to recharge the aquifer. When it's pumping more than is naturally going back into the aquifer, they're bringing in Colorado River water, which is very different from the native groundwater in the area, and putting hundreds of thousands of acre feet on during some years into the groundwater aquifer. Some of the problems with Colorado groundwater include a very high TDS level, very high salinity, and a very large number of other contaminants of emerging concern. So this is just a nice picture that shows the water spreading facility. This is the Whitewater water spreading facility. It's located just northwest of Agua Caliente's reservation, their land base. Facility here, we also have the hydrological ground flow that goes pretty much directly to the tribe's reservation land base. The effects of the recharge are becoming very apparent, as we'll see in a couple slides here. So when we look at the changes in groundwater TDS levels, this is data from a well that is east of the ground spreading area, directly east. And as you can see, this is the average Colorado River salinity. This is the level of TDS measurements in that groundwater well over a period of years, beginning about the time when the water agencies began to recharge the aquifer with Colorado River water. So we can see a very dramatic spike in TDS levels at that well that is down gradient from the water spreading facility. We also see increased salinity in the groundwater at a test well on the reservation. This is a really great graphic that kind of drives home the point that we look at the activity, how much water is being recharged, and we look at what the average salinity is, and there's a pretty striking correlation here between the activities of the water agencies and the declining quality of the groundwater in the Coachella Valley aquifer. So the tribe, again, repeatedly voiced these concerns and said, look, we have a right to this water. This is our home. This is, where our ancestors lived for millennia before you came. And we plan to be here for millennia from now. And we want to make sure that we have water that is fit for human consumption well into the future. And the water agencies basically told the tribe, look, you don't have any water rights. You don't have a federal water right. There's no federal water right to groundwater. Winters doesn't, you guys need to just pay your water bills and deal with what we're doing. And basically told the tribe to go pound sand or drill your own well and deal with your issues there. So that was sort of the dynamic that had continued over the years. And finally, the tribe had really no choice left but to go to court because nobody would discuss any other resolution of the concerns that they had been raising for years. So the lawsuit filed by Agua Caliente in 2013 seeks declaratory and injunctive relief. First off, the tribe seeks a declaration that it has the winter's right or federally reserved right to the groundwater within its reservation, and also to the pore space in which the aquifer, that the water in the aquifer exists in, and that by replenishing the aquifer, the water agencies are using a resource that belongs to the tribe, namely the pore space in the aquifer below its reservation land base. Additionally, the tribe has asked the court to enjoin the water agencies from bringing the Colorado River water in and replenishing the aquifer with it without any sort of treatment whatsoever or without addressing the quality concerns. In almost exactly 1 year later, the United States intervened in the case, and another interesting factor that sort of plays into all of these different concerns, the recharge facility through which the water is recharged by the water agencies exists partly on BLM land. And of course, most of us know you need a permit to operate on any activity like a recharge facility on federal land. And so the water agencies' permit expired in 2014. There's a requirement in the regulations that, a renewal application has to be filed in a certain window before your permit expires. They didn't do it. They didn't file a renewal application, so the permit did expire. They have filed a new application for a new permit, and the BLM is treating it as a new application at this point, and we're in the initial stages of NEPA review on that new application. So that's another interesting wrinkle to the whole case, and how we're looking at solutions that might be, I guess, mutually beneficial to all of the parties if people would become reasonable and talk about things in a reasoned way. Water District's response to the tribe's lawsuit when it was filed. I don't want to editorialize, but somebody else talked about extreme lawyering positions or extreme legal positions. And really they just said, look, the tribe has no federally reserved right. You guys have state law rights, use them, which is probably not the best response, and maybe not the most consistent with working out how people share a resource that everybody needs and wants to see become sustainable. They also asserted that the surface water rights that were issued by a court in the 30s over the objection of the United States with a couple surface water streams that don't flow all year were enough to meet the tribe's needs. And those, again, are ephemeral flows coming out of the mountains that are immediately absorbed into the desert floor when they get down to a lower altitude and don't run all year in any event. So those are some of the legal offenses that the water agencies raised. They also asserted 3 equitable defenses: latches, balancing of the equities, and unclean hands against the tribe in the United States, saying you can't bring these claims because either you waited too long, tribe, you've been using the water through our infrastructure all these years, your hands are not clean. United States, you have permitted us to recharge this groundwater for 30 years, and how can you now bring a claim saying that we shouldn't be doing things the way we've been doing them? So those are some of the defenses asserted by the water agencies. And very, very strong body of case law that said most of those defenses do not apply to reserved water rights claims, but they asserted them nonetheless. Early on, after the tribe filed its lawsuit, the lawyers agreed to trifurcate the case, to split it into 3 phases. And this was done, I think, to make sure that we were able to progress with this litigation and settle some of the very big issues, legal issues at the outset, without engaging in the very time-consuming and expensive process of quantification and bringing in other parties who may or may not have an interest in the case, really to determine the legal merits of the tribe's claim at the outset rather than go into extensive factual determinations. So phase 1 was the existence of a reserved right to groundwater. Does the tribe have a reserved right? Does the Winters Doctrine apply to groundwater? Some people consider this to be a huge legal question. Not all of us agreed, but you know, there were I think a lot of folks out there wringing their hands saying, "Oh no, what is going to happen with Winters' rights when Agua Caliente hits the Supreme Court?" And thankfully, we did not see the Supreme Court take an interest in looking at that issue this past year. The second issue would be quantification standard. What standard will apply to quantify the tribe's water right? There are a number of different, well, there are really 2 or 3 different ways that I think the court could look at determining just how much of the groundwater is the tribe's water right, and whether the tribe has a legal right to the pore space, whether they own the pore space under the reservation, or what the nature of that right is, and whether the equitable defenses, those 3 defenses of unclean hands, latches, and balancing of the equities, whether those apply to this claim. Phase 3 will involve quantification and any other defenses that may be asserted. So phase 1 progressed, and the district court, Judge Bernal in the Central District of California, ruled in favor of the tribe. He ruled that when the presidents withdrew land for Agua Caliente, they also reserved by implication the right to appurtenant water in the amount necessary to fulfill the purposes of the reservation, and that any attempt to limit appurtenant water resources to surface water fails as a matter of law and logic. So obviously, this reservation was established. Everybody knew there was no surface water. What was the intent? How was that need for water intended to be fulfilled? Well, obviously, it was always intended that the tribe would be able to use groundwater to fulfill its reserved rights. The judge also noted that with one exception, every court to address this issue agrees that Winters' rights encompass groundwater resources. And this was certainly not the first case to go there. There have been a number of state court decisions and even federal court decisions that recognize that groundwater is a good source for fulfilling reserved rights, especially in the context of Indian tribal reserved rights. We, let's see. Yeah, and accordingly, the court held that the government impliedly reserved appurtenant water resources, including underlying groundwater, when it created the tribe's reservation. Well, almost immediately after the district court issued its ruling, the water agencies sought an interlocutory review of that question about whether reserved water rights include groundwater. And the Ninth Circuit heard the arguments and agreed to hear the interlocutory appeal, and we proceeded to brief those. And we also, at that point in time, went ahead with briefing on one phase 2 issue, which was the applicability of the equitable defenses, another very clean legal issue that we thought was very suitable for us to move forward on at that point in time. So we won on that issue as well. The district court ruled that none of those defenses applied as a matter of law to bar a claim such as the one sought by the, asserted by the tribe here. Again, I think it was fairly, again, a fairly straightforward legal analysis of whether those claims applied. Nothing really groundbreaking there. So the Ninth Circuit, in its review of the reserved water right ruling from the district court, looked at, again, at the very large body of case law that holds that tribal water rights can include groundwater, reserved water rights can include groundwater. And one of the main arguments that the water agency set forth was that under the US v. New Mexico decision, there was no tribal water right here, basically. There's a purpose, but you don't need it because you've already got it under state law, so New Mexico would bar you from getting any water as a matter of federal reserve rights. Kind of an interesting argument, and not one that was well accepted by the Ninth Circuit. The Ninth Circuit said, okay, if we look at U.S. versus New Mexico, we're going to look then at what is the purpose of the reservation. Well, it's a permanent homeland. Okay, so then the tribe has a reserved water right to an amount of water, any water, sufficient to fulfill that purpose. This is the purpose, and there's a right for it. And any appurtenant water source can be used to fulfill that right. Yeah, so again, the Ninth Circuit looked at 3 steps first, looked under New Mexico, said that the court needed to determine what the purpose of the reservation was. We had that, we know that. Then looked at whether winters extends to groundwater, and the Ninth Circuit agreed with the tribe in the United States that, of course, the winters doctrine extends to groundwater. It only makes sense. It's a really wonderful moment during oral argument before the Ninth Circuit when, questioning one of the water agency's attorneys, one of the judges said, hey, look, I've been there. You're saying there's surface water that's sufficient to get through? Well, yeah, the Whitewater River flows right through Palm Springs. And the judge said, well, I've been there. I've driven over that river, and I've never seen water in it. Never, right? And another one of the panel members asked, again, one of the water agency's attorneys, well, you're asserting that the tribe has no water right. Right, yeah, there's no reserved water right. Did the United States establish this homeland for the tribe without the intention of providing water for them? Yeah, there's no purpose there. But they intended for the tribe to live there. And if there's no water, the Indians would die. It was a very dramatic moment, and there was no really good answer for that, right? I mean, but well, of course. People need water. These tribes have a right to water to continue to live and to exist and to survive, even if at the time when the reservation was established, people were actively trying to exterminate Indians. But this reservation wasn't set forth with the purpose of letting the Indians die on it. It was set forth so that the tribe could build, thrive, and survive, which is what they continue to do today. Oops. So this is just sort of the wrap up with that. Again, the Ninth Circuit really put to rest those assertions that state law somehow preempted the application of federal law here to establish the tribe's right. And the water agencies, of course, and immediately petitioned for certiorari before the Supreme Court, saying, oh my gosh, the sky is falling. This is the craziest decision the Ninth Circuit has ever issued. It's so out of touch with every other circuit. You guys have to take this up and deal with this issue. And the Supreme Court denied certiorari on November 27th of last year. And we all breathed a huge sigh of relief. We had an ongoing debate with a couple of other attorneys for some of the higher profile Indian law cases that are currently working their way through the federal court system. Like, I bet you guys are going. No, you're going. No, if you go, we're not going. So yeah, anyhow, we were relieved we didn't draw that lucky card this round. Phase 2 briefing is now complete when we're back to the rest of the case that we're still involved with. And again, that's the issues of what the standard for quantification will be, whether the tribe owns the pore space under its reservation, and whether there's a water quality component to a winter's right. Because again, one of the key drivers of this litigation was the deteriorating quality as well as quantity of the groundwater below the reservation. And so, there's a fairly common sense argument. You put Indians on a reservation. Obviously, you intend for them to have water. Well, if you intend for them to have water, do you intend for it to be fit for consumption? Do you intend for it to be fit for use? And what can the tribe do to make sure that the water stays at a reasonable quality and that some of these contaminant levels are abated and that the tribe has a stake in making sure that this water doesn't become too salty to use in the foreseeable future. At the same time as we were wrapping up the Phase 2 briefing after certiorari was denied, we were offered the opportunity to go into informal mediation with Judge Levy, who's a senior Ninth Circuit judge sitting in Portland. And, I think that's a really interesting and encouraging development in the case that, the parties are initiating that process of potentially negotiating a settlement and starting to talk about what that might look like. It's very, very initial stages of those discussions, and we'll see where they go. So that's my update on Agua Caliente, and I tried not to editorialize too much, but it's hard to do sometimes. So anyhow, I'll look forward to your questions later on. Thank you.
Questions now, since you're going to step out, or do you want to?
Yeah. It's